Thanks, Cahir. Well, the Qualifications and Quality Assurance Education and Training Amendment Bill, I believe, Minister, it is a very timely and important piece of legislation, you know, to protect the reputation, I suppose, of all aspects of higher education in this country, and especially of the students themselves, whose families have often made huge efforts to provide you know, English language and other third-level education for their children, including students obviously from outside the EEA. And as colleagues have mentioned, of course, the protection of the teachers, the workers in the sector, is also vitally important. And just looking at the bill again, I mean, you don't seem, though, to have included any additional sections in that regard, because people recalled obviously the collapse of Grafton and the way people were left without wages and so on, which of course only happened a few months ago. Just last Saturday, Cahir, the Guardian newspaper published its annual rating of the 80 or so British universities, and with, I think, St Andrews of Scotland beat Oxford into second place. Cambridge, of course, was first. And I looked out for the positions of the colleges of one of my own alma maters, which was London University. But that analysis for The Guardian, of course, it focused keenly on students' experiences and on the quality of teaching. I'm not really aware of a similar annual study of Irish third-level institutions. But obviously, with this legislation, perhaps that's an area that we need to look at, not just in terms of rating institutions, but actually looking at the overall quality of the work that they do. The British and Irish colleges, of course, all depend for significant income on the numbers of international students, and providing them, as well as our native students, with a quality education, it has to be the hallmark of third and fourth level training. The acute need for the bill before us, of course, Cahir, emerged following the decision of the High Court in 2015 that Quality and Qualifications Ireland QQI, established under the 2012 Act, didn't have statutory powers to operate the ACELS, the Accreditation and Coordination of English Language Services accreditation scheme. The background, of course, to the High Court case was the well-publicised closure of several schools which offer diploma-type awards to international students, and I think in that period, Minister, wasn't it, from the summer of or the spring of 2014 into early 2015, something like 16 schools closed, and we had students, of course, marching in different parts of the city and around the country, and you know, highlighting the amounts of money that their families and themselves had spent in trying to get an education. Miss Justice Baker, of course, in her judgment in 2015, she noted that the students from outside the EEA could obtain a Stamp 2 visa, permitting them to remain in the state for 12 months, studying part-time course for 6 months, and then a further 6 months of full-time work. And the judgment, of course, mentions and details poor standards and attendance records from some schools, and a perception that some students were in fact economic migrants, mainly interested in seeking work. And of course, some of those went on to seek Stamp 4 and full residency status in Ireland. And I think we all have experience in the Chamber of representing some of these students over the years, some of whom, of course, have acquired Irish citizenship. But Ms Justice Baker did point out the very particular role that these schools, in fact, play in this whole area. I know that QQI currently has the power under Section 61 of the 2012 Act to award the IEM, the International Education Mark, which can be displayed by an education provider to show the college or school complies with standards, procedures and practices mandated by QQI. And Section 25, of course, of the bill before us, I believe, rightly expands and clarifies QQI's powers to introduce and award the IEM. And I note also that QQI has published its Code of Practice for provision of programmes of education and training to international learners, and I think Section 25 will now put this Code of Practice for such education providers, won't administer on a full statutory footing, and that's certainly to be welcome. QI, of course, may also in Section 25 establish and publish different codes of practice for different relevant or linked providers, or for groups of those providers, and for different classes of programmes, which is also welcome. But just as in the UK, of course, Irish higher education, we have derived much resources, I suppose, in the economy from the teaching of international students, as my colleagues here earlier on have mentioned. Our excellent Bills Digest, which was done on this bill by the Oireachtas Library and Research Service, tells us that the CSO report reports that the direct output of English language training, private and HEA-funded institutes was approximately almost 800 million, in fact, in 2014-15, and the further economic outputs of the sector produced an additional 800 million, so bringing it in total to about 1.6 billion. I know it's the policy of your government, Minister, to try and develop this to around, or was to develop it to around 2 billion net benefit to the economy by the coming academic year. But a core principle underlying the development is the protection of the enrolled learner, the Pell, the students themselves. And I note that in Section 65 of the 2012 Act, which made arrangements for QQI to protect these students where an education provider is unable to deliver a programme. But hopefully this provision will be greatly strengthened by Section 25 and the other sections of the bill before us, like Section 27, 28, and particularly the creation of the Learner Protection Fund. I note that Section 29, of course, replaces 66 of the 2012 Act, and that provides, in the event of the college programme defaults, the Learner Protection Fund may be used by QQI to defray costs of completion of the enrolled learner programme and defray payment of fees for transfer onto another similar programme with a different provider, or to pay a refund to the enrolled learner. So I think that section and the creation of this fund is very, very welcome. And over the past decade, of course, or so, as Deputy O'Sullivan referred to as well, there has been an explosion, I think, Minister, of online services providing essays and reports for third-level student assignments. And again, I note that Section 15, or the new Section 43A of the 2012 Act, will try to address this development of effectively online cheating and crimes of, indeed, of impersonation and other attempts to cheat and unfairly manipulate exams. So we have a new section, I think 43A now, for the Principal Act, which will make an offence to provide or advertise cheating services, including undertaking assignments for an enrolled learner, sitting an exam in the enrolled learner's place, or providing answers for an exam without authorisation from an examiner. Of course, a number of studies, as our digest tells us, they've been carried out into contract cheating at third level. Many show, though, that jurisdictions like the UK, Australia, New Zealand, Canada and the US, they have criminal legislation in place, but the laws so far haven't been very effective. And, of course, some of the problems with implementing this type of law are the international nature of contract cheating, and due to the internet and the fact that plagiarism may be difficult to prove, or sometimes regarded, in fact, as a moral transgression rather than what it can often be fraud, a criminal act. Clearly, the new Section 43A and Section 15 of the bill seems well justified, and hopefully that will be a basis for preventing some of this behaviour. I think Section 35 of the bill is also very welcome, which gives the Institutes of Technology their own award-making powers. But and again, I just wonder that you excluded, of course, doctoral awards in that provision, Minister, and I didn't hear your introductory speech, but I just wondered what's that based upon? Because clearly the third-level sector, my own hope, I think many of us would be that all citizens are entitled to third-level education, and that all of our key universities and technological universities should have, and institutes, I think, should have the full degree awarding powers. So I think the reforms encompassed by the bill, they are very timely. The events of 4 or 5 years ago, which led to the closure of those colleges and the mistreatment of perhaps at least 3,000, mostly non-EEA students, was totally unacceptable. And again, between 2010 and 2015, of course, the number of those students increased almost 60% to around 33,000, and specifically in the English language sector, about 106,000 students were in English language training institutions. I noted that Deputy Lahart, of course, referred to if Brexit happens, as maybe seems more likely now, that we'd be the only English-speaking country in the European Union. That's maybe excluding the Netherlands, where English is more or less a second language, and but we will be the only native speakers, I suppose. But hopefully the measures before us will give QQI all the necessary powers to police and vigilate the sector, and as Deputy O'Sullivan was saying at the committee and the further presentations, hopefully some of the remaining problems may be addressed. Thanks, Cathaoirleach.